Welcome to the Trust Factor Radio, bringing you interviews and insights to unlock the power of the subconscious mind to create authority, credibility, and trust. With your host, the Authority Architect and best-selling author, Neil Howe.
Hello and welcome to the show. This is your host, Neil Howe, and my guest today is Deborah Danger. And Deborah is with the Danger Law Firm in Newtonville, Massachusetts. And we're going to be talking about many things today, but probably focusing mostly on estate planning and what you need to do to get your affairs in order as you are getting up in age. Deborah Danger, welcome to the show.
Thank you very much, Neil.
Well, give us a little bit of your background to get started, how you got into the attorney business and how you got into the fields that you are helping people with today.
I would say the short answer is I'm a very thorough researcher. And as I got older, I had questions of my own about estate planning and how to structure my kind of end of life and my transition between now and then. So I ended up going to law school when I was 43, graduated when I was 46, and just had a natural affinity and curiosity for this field. So this is my second career. My first one was financial analyst doing a lot of Excel spreadsheets. And so I find that the confluence of kind of the numbers as well as the words in the law kind of is a good place for me to sit and help people and also just feed, as I said, my natural curiosity about these topics.
Yeah, I mean, those are two things that can be very confusing to people is the finances and the law. So to be able to put those two things together means that you really position yourself to help a lot of people. Now, tell me exactly what estate planning is, because you know even that term many people might not know exactly what it means.
So estate planning is what you own when you die. But now that we're living to be 150 years old, that's expanded. So now the umbrella pretty much covers that, plus what happens if you become incapacitated or your capacity shrinks such that you need help. So there are documents that allow someone to step in your shoes and make healthcare decisions for you when you're not up to the task, but also manage your affairs, whether it be investing your money, paying for your regular services, filing your taxes, anything else that comes in. So not only does that help when you're aging, but that also helps if something happens and you have kids. It's a message to the court who you would like to step in your shoes and take care of your kids as well if you become incapacitated or pass away and you have younger responsibilities.
So at what age should somebody really consider to, have their estate planned, or what does that involve? Does it involve a will? Is that the main purpose of it?
So if you're 18 or older, you are considered an adult. And so therefore, while the obvious choice might be that your parents should make healthcare decisions for you or be able to gain access to your bank account to get in touch with your student loans or just pay your bills, you need those two documents. I'm not so concerned about a will if you're that young because you probably don't have that much stuff anyway that has to be contended with. But I am very concerned about you and your folks because otherwise they'll either need to go to court, which no one wants to do, or be very good at persuading people to break the law, which not very many people are very good at.
No.
So
basically you need a plan. You need some kind of plan, not necessarily a will, but you need the authority to give access to, whatever to the right people.
Yeah, and I don't think that's even much of a plan. If you want your parents to be able to keep taking care of you once you turn 18, then you can name them. If it turns out that you have a partner, girlfriend, boyfriend, a spouse, then then you should name them, because someone should be able to step up for you, because you're no longer wards of your parents. So that's why that change becomes pretty dramatically important when you turn 18.
Mhm.
When you get older and you start getting stuff, or if you get married and you suddenly want to name your spouse, because marriage does not give your spouse the right to make healthcare decisions or manage your affairs. So the next phase is usually you meet someone who's important to you, whether you be married or you own real estate together or you live together or you're just dating on a regular basis. If you'd like to name that person, you should tell the world. And the way to do that is through a healthcare proxy and a power of attorney. If you also want that person to get your stuff, if you want that person to be able to get control of the checking account that you used to pay your rent, or the house that you bought together, or help you continue to run the business that you founded together, then you need a will, because a will is a document that speaks at death. And it's kind of like, in a really lame way, your last letter. And you say, "Dear, to whom it may concern, these are the things that I want to give away. These are the people I want to get those things. And this is the person that I want to administer all of the legal requirements so that my things go to whom I wish." In addition, when you're doing your will, unlike where you, in your will, you could specifically nominate who gives your stuff away, all you can do with your kids is recommend who will take care of them. And the reason for that is because while this document is set up in the present day, we don't know what's going to happen in the future. So we need the court to supervise your choice. So if you have nominated your partner or your sister to be the guardian of your child, and when that person is called to fill that role, that person is addicted to something, or is in prison, or is just not up to the task, then the judge gets to overrule your recommendation because you couldn't foresee what was going to happen. And the judge will name someone else that, in the judge's interest, and the judge's perception, is in the best interest of your child. So for that reason, I recommend people name 2 or 3 alternates. I want my sister, but I would also like my grandmother or my best friend from college if the previous named people aren't available.
Yeah, and I can imagine that is something that, I certainly wouldn't have known that myself if I wanted to fill out my own will or estate plan rather than using an attorney. These are some of the things that you wouldn't think about. And then, like you said, it would be in the hands of the courts to make the decision for you. So what other benefits are there working with an attorney like yourself in order to do an estate plan rather than going to LegalZoom and trying to do it yourself?
So I have 2 things. One is accountability. I can't say a lot, but I frequently get calls from people who say, 4 years ago I paid 99 cents for a will package and I just can't seem to get it done. Of course not, because for 99 cents, no one's going to keep calling you up or meet with you or work with you and kind of prod you along to get the job done. I can tell you that last week I met with people who purchased Susie Orman's will package, and turns out that that particular company is based out of California. So California's laws are different than Massachusetts laws, and it's not that the document wouldn't have accomplished it, but I think it would have been a lot more trouble because the document was governed by California laws, even though their estate was in Massachusetts. So why would you want to pay someone in California who understands California laws to probate an estate that's here in Massachusetts? It probably seemed like a good idea to spend 99 cents on that, but in the long run, it's probably going to cost you more money.
Right.
I also want to share another story that I have a family. Mom was in the hospital, 3 kids. Older brother said, "Come on, sis, let's meet at the hospital. We'll do a will for mom." And they drafted a will, and mom left everything a third to the 3 kids. And then the oldest brother and the middle sister had mom execute the document. They witnessed the document. There was a notary there. Terrific. All was great. Then mom died. Well, it turns out in the Commonwealth of Massachusetts, you can't simultaneously benefit from the will and witness the will, because your credibility as a witness is undermined by the fact that you're benefiting from the will.
Mm.
The Commonwealth of Massachusetts also really wants that will to survive. This is their mom's last wish that this happen. So therefore, in order for the will to survive, the two witnesses can't benefit from the will. So even though the brother was trying to do the right thing, he ended up disinheriting himself and the middle child, and all of the money went to the only remaining beneficiary in the will, which was the youngest sister, which is not what anyone wanted, but that was the end result.
Wow.
I know.
I mean,
Crazy,
those kinds
right?
of things, like I said before, those kinds of things you just don't think about. And to have that expert in your corner could really prevent a lot of problems happening. I hope they were able to sort something out and it was amicable, but I know many times with families, things aren't amicable.
Correct. Money changes people.
Yes, it certainly does. So, the overall question is, does somebody need a will in place before they die?
It certainly makes things easier because we know what your wishes are, and we know who you want to do stuff, who you want to get stuff, who should be responsible for your kids. And also, if you're doing a will, hopefully you're taking some time to identify where your checking accounts are, where your CDs are, verify the beneficiaries for life insurance account. But if you don't have a will, guess what? The Commonwealth of Massachusetts has an estate plan for you. And that's why I'm not concerned about an 18-year-old, because if you're at 18 and you're in college and you pass away, everything you have is going to go to your parents, because it just is. That's what the Commonwealth of Massachusetts thinks you might want to have happen. And if you don't write it down, everything's going to your parents. Where it gets tricky is let's take that couple that I just talked about. They're married. Let's say they don't have kids. And ideally, the predeceasing spouse, let's say it's the woman, would really like everything to go to her surviving spouse. Let's say it's a man. Well, if she dies without a will, what Massachusetts thinks this woman would want to do is care for her parents as well as her husband. So her estate is going to be split amongst her surviving spouse and her surviving parents. And if their largest asset is a house, then the surviving husband is going to end up co-owning the house with his in-laws.
Mm.
So if you don't have a will, things will get sorted out because they have to. And that's why there's a law in place, but it's not always reflective of what your wish would actually be, which is why, yes, I think everyone should have a will. Yes.
So what are the different sections then you look at within an estate plan?
So as I said, I bifurcated into two things. Incapacity, which is healthcare decisions and managing your affairs. And then there is the will, which speaks of death. And then there's an overarching document that covers both, and that's a trust. And so if you own things individually, you have a bank account and you pass away, your bank account has to be probated. And under the Commonwealth of Massachusetts, by statute, that probate can't happen any sooner than a year from your date of death. And the reason for that is Massachusetts gives creditors a chance to file claims. MasterCard, Visa, the ambulance, the IRS, anyone that you owe money to gets a year to say, hey, Neil owes me money. And then at the end of that year, whoever is administering or probating your estate says, okay, ambulance company, IRS, MasterCard, Visa. And then they go to the judge and they say, Your Honor, you're supervising this because that's why we went to court. I've paid all these people. This is what's left. I would like to distribute the rest of Neil's account to the people that he's named in his will. And the judge says, fine, there you go. Now, if you create a trust, what I'm going to suggest is that you give your bank account away to yourself as trustee. So now you don't own it individually anymore. You own it as a trustee. And you name a successor trustee. Now, when you pass away, I can tell you it's impossible to simultaneously be a trustee and not living. So as soon as you pass away, you vacate the office of trustee, and your successor is now the owner of that account because the trustee is always alive. So now we don't need to probate your estate because someone living continues to own that account. You probate something if you owned it individually and you died, but your trustee owns it. So therefore, if you pass away in the morning, we can be very sad, but distribute the proceeds of your checking account in the afternoon, but setting aside an estimate. We think the ambulance bill is going to be $400, the IRS will be owed $1,000, but the rest of it can go almost immediately as a way of continuing to take care of your family and just getting money to those that you love now that you're no longer using it more quickly.
Okay, so to be clear, the probate is a specific length of time. Is it always a year?
In Massachusetts, probate is essentially taking an asset that's in the name of someone who's no longer living, and with court supervision, transferring it to the name of someone who is. And by statute, that transition has to wait a year so that creditors can file claims and be paid before the money is distributed.
Okay, and in the case, if it is in a trust and there are still creditors to be paid, what happens then?
It's more on the honor system. It's these people still have to get paid, but we don't need to go under the jurisdiction of the court. It can just be done amongst the people that you trust. That's why you're calling them a trustee.
Okay, great. So obviously people getting up in age are the ones that they've lived their life, they've built up their financial nest egg, and they might have something to give away at the end. What are some examples of how that actually pans out?
I don't understand your question.
What kind of things normally happen when somebody of age has passed away? They don't have a spouse maybe, and they're leaving it to their children. Do they leave it to the church or to charities, or what kind of options do they have to separate?
So there are a number of. So let's start with the two different types of assets. There are some assets, as I said, that you will own individually or as a trustee. And you can give those to anyone that you would like. People that you love, charities that you support, strangers that you would just like to tickle their fancy. There are other assets. Ones that come to mind are life insurance, retirement accounts, annuities, where you name a beneficiary. And similarly, you would name those same people that you would like to benefit. And if it's a life insurance account, the other great thing is that's a contract. So the person has signed a contract with the life insurance company that says, as soon as someone proves to you that I'm dead, I'm going to shoot this money out to the following three people in equal portions. So all we need to do is get in touch with the life insurance company, give them a certified death certificate, and the money gets paid pretty quickly. That's why life insurance is so important to younger parents, because they need that money to buy food, to pay the mortgage, and all that kind of stuff. There are more clever things that you can do, like giving your money to charity now in the form of an annuity that serves you, but then when you pass away, the money stays with the nonprofit. There's also gifting that you can do to your grandchildren. Every person that you know and love, you can give up to $15,000 a year without having to file a tax return. So that if you come in and we do some analysis and it turns out we think you have more money than you will need to last the rest of your life, then we can do some planning. If it turns out that you have less money, well, there's also planning we can do, but we just need to know. The sooner we know about it, the better the plan can be.
Mm. Let's talk about that last part that you talked about for a minute. If there isn't really enough money left, what do people do in that situation?
So in many instances, they do nothing. Whether it be, oh my gosh, I don't know who I should name. I don't have any friends. I don't have any family that are nearby. I don't have any neighbors that I trust. My neighbor's doing the same thing I am. So I'm not going to do it because I don't have anyone to name. Well, that's another good reason to meet with me. Let's figure it out. Let's brainstorm about who you can name, because I'm more worried about you if you're incapacitated, because then your life is going on and I want to make sure we've got a plan for you to get care. Even if the plan is that you spend all of your money and you go on Medicaid, I want that to be a plan. I don't want it to be a happenstance that victimizes you. So that's ultimately, if you don't have enough money for care, then we should plan for you to go on what's called Mass Health in the Commonwealth of Massachusetts, but something that will allow you to be cared for, and acknowledge that you probably don't have enough to get to the end of the runway. The sooner that happens, the better.
Yeah, so it's all about just being able to think forward and planning out the rest of your life. What percent of people would you say actually have an estate plan and those that don't?
Well, it's tricky because there are people that have an estate plan and I know it works. There are people that don't have an estate plan and we know that it doesn't work. And then there's this fungible group in the middle who probably have an estate plan from 1972 and they've named people that either aren't still alive, don't have capacity, they don't trust, they're not in touch with. So it's not black and white, but I would say everyone would benefit from a kind of an under the hood checkup. I myself review my own plan every 3 years. I'm surprised by how much happens in those 3 years. So if you're looking at 10, 15, 20 years, I think we'd all benefit from just being a little more thoughtful. It's supposed to be a living document that represents our wishes. But for many, it's a document.
I'm sure that's a big question that many people have on their minds, is how often they should update it. And you say about every 3 years would be about right?
Every 3 years, and then you're going to procrastinate, so it's going to end up being every 5 years. So I think that's a good window to try to climb through.
Well, let's talk about some of the myths and misconceptions that people have when they think about estate planning. What does that really mean to them if they don't really know?
So I would say the first myth is people think they need a lot of money. And as I just said, a large portion of my concern for my clients is incapacity. And so anyone who is alive should meet with someone to capture their wishes of who's going to take care of them if they're still alive and they can't do it themselves. Similarly, with a will, we all have something. So rather than have people, I mean, we just talked about those 3 kids. Everyone wants to know that you're thinking about them, anyone who's important. So just naming people, even if all you do is just say, to my brother who founded Microsoft, I just want to say how proud I am of you. And to you, I leave my admiration, my respect, and my love. That's a gift. That means so much to the person that you wanted that person to be one of the last things that you thought about. That's so significant. So if you have anyone that you like, you should have a will. The other misconception that many people struggle with is that if you start doing estate planning, as soon as you sign your will, you're going to hit by a bus and die. And I promise you the exact opposite will be true. Most people are surprised. Oh my gosh, I feel so much better. I didn't realize how heavy this was weighing on me. I feel the same thing. I'm getting close to my 3-year review my estate plan documents, and it's just starting to kind of eat at me like, oh, I can't remember what I said 3 years ago. I can't wait to find time to sit down and review it and bring it up to speed. So The other myth is that how amazing you will feel when you finally take care of yourself and the people that are important to you.
Mm. And as far as mistakes that you see people make that end up costing them, what are the biggest mistakes?
So not doing it is very, very expensive. I will say, so the difference between a will and a trust is the amount of time it takes to draft a trust. You talked about going on the internet, getting a will. We talked about how there are errors that had just happened from that. But even if you come to me and you say, all I can afford is a will, then let's get it done. But I will say that a trust helps you avoid probate. So if you can come up with the money to do a trust in the beginning, there'll be more to go to your friends on the back end. I will say people wait too long. So that if you wait till you're in the hospital and you're pumped up on morphine and you have 3 kids and you leave everything to each of them equally, it's not unusual for one to come back and say, gee, mom didn't have capacity, and I know that mom wanted me to get more because I've spent the last 2 years at the hospital. I quit my job, and mom always told me that she wanted me to have more. Well, we don't have any documentation that that's the case, but mom waited too long, so she couldn't. Her capacity is challenged, so we're not sure what she really wanted because she did it on her bedside 2 days before she died. We can't even tell it's her handwriting. So there really is a benefit to planning because if you do that, I have a client who is leaving his estate, like his real estate and his money, to the 2 kids that live close to him because they come over every day and help him with his meds, and he gets to see his grandchildren, and everything is great. He's got 2 kids that live out of state that he never sees. Well, they're the beneficiary of his life insurance. It's less money, but it's a little bit of something. Money equals love, so they get some love. He's doing that now while he's healthy. I have him reaffirm it every 5 years so that if anyone challenges that this is not his wish, I have a paper trail that says, look, for the last 3 meetings, this is what he's wanted. So it makes it harder to challenge because you're planning. You're planning for what you want, and you're planning for people to push back.
Now, with the rise of Alzheimer's and dementia, how has that factored into people being able to sign a will or a trust?
That's another reason to plan. It's a double-edged sword. On the one hand, it's a very low threshold. So if there's 3 kids and they all agree that mom needs a healthcare proxy and a power of attorney, and it should be the eldest, and then everything should be split equally. And I go over on a Wednesday morning when it's sunny and bright, and mom knows that who the president of the United States is and what the season is and what the date is. I'm willing to sign that document because it facilitates what everyone in the family wants. If, on the other hand, I get a call from the son who says, mom told me she wanted to leave me everything, and the daughter who says, mom told me she wanted me to leave her everything, and another daughter, now there's not much I can do because we've waited too long. Or if I go over and it is still sunny and I ask the person, I actually had a client and I said, who's the president of the United States? And she said to me, I think Eisenhower is doing a magnificent job.
Wow.
And good for her that that's where she was, but I can't execute a document. So in contentious cases, I've asked our neurologist to evaluate the person's capacity the day before the documents are signed and the day after. So I have documentation that a medical expert deemed this person to know what he or she was directing, but that doesn't often happen.
So what fears do you see that hold people back from actually getting this done?
So lately I've met with a lot of people. They're called elder orphans or solo agers, people who are not married, don't have kids, don't have friends, don't have relatives, and that paralyzes them because they don't know who to name. And those are the people that I feel like there's an urgent need to meet with them, because they have, not only do they not have anyone to name, they don't have anyone that they've shared their wishes with. If mom doesn't have a healthcare proxy, you've talked to mom for the last 80 years. So you kind of know where she stands on, if I wake up and I don't know who you are, what would you like to have happen? So working with the elder orphans or the solo aging population to help them figure out, is there a professional fiduciary that we can put in place? Is there a care manager that we can just interview you with? One of the tips I tell people is, if you're thinking about going to assisted living, go when you think it's too early. Go when they know who you are. They understand that you used to play the flute, you like chocolate ice cream, and you enjoy sleeping on your right side. Because if you wait too long, and when they put you in the facility, you don't have any personality, you don't have any ability to communicate, then no one's going to know how to plug into who you are. And so the same thing with those documents. Meet with someone who can help you figure out how. Don't be afraid of aging. Acknowledge that it's going to happen, and let people help you figure out how to get around what you think is an unnavigable situation. Because I promise you, you're not the only one in that situation, and there are people that we will brainstorm about and identify and help you feel better.
Well, there's certainly a lot to think about, personally as well. I think about my parents are getting up in age, and I'm sure it's sparked questions for many people listening here. It's got to be good for you as well, Deborah, for the position that you put yourself in, being able to help all these people get prepared.
Yeah, and I will say, what you said just made me think about, I have people, and I've alluded to it, that do unconventional things, like the gentleman who's leaving more than half of his estate to half of his kids. And in those cases, like with your folks, if you're going to do something that's unconventional, then talk about it while you're still alive. I have many family meetings where mom says, look, I had 2 kids. One went to private school, the other went to public school. So guess what? The one that went to public school is getting more, because I feel like you got your inheritance by paying for the private school tuition. And I just wanted you to hear that from me. And I want you to be able to ask my attorney, who's in the room as well, questions. I want you to know this is truly my wish. It doesn't mean I don't love you as much. It's just, I've been thinking about this since you were 18, and it feels fair to me. That is such a great message to get from the parent, not from the document, not from the lawyer, not from the other sibling who is named as the executor of the estate.
Yeah, there's definitely some difficult conversations probably that need to be had, but guidance is needed through that as well. So, Deborah, if somebody is looking for help and guidance through that process, what is a way that they can reach out to you in order for you to help them?
So, my phone number is 617-789-4511. Because I'm old, I love to talk on the phone. So I take phone calls, I answer my own phone. You can also email me at Deborah, DEBORAH, at DangerLaw, DANGERLAW.com.
Excellent. Well, this has been highly educational. Like I said, has got the thought processes going in myself, and something that I'm going to have to take some time to think about these things for, not only my parents, but my family as well. So, Deborah, thank you very much for spending time with me today. And I hope the information that you've given is definitely going to help other people as well. And again, that is Deborah Danger from DangerLaw, LLC in Newtonville, Massachusetts. Deb, thanks very much for being my guest on the show today.
Thank you for being such a wonderful interviewer, Neil.
And to our listening audience, if you like what you hear, hit that like button and share, and we'll see you next time on the show.
You've been listening to the Trust Factor Radio with Neil Howe. To learn about the resources mentioned in the show and to listen to past episodes, go to thetrustfactorradio.com. To get a copy of the book, The Trust Factor, go to thetrustfactorbook.com. If you are ready to act now and build your authority, credibility, and trust, schedule a consultation with Neil at theauthorityarchitect.com.